Hey folks, this is immigration attorney Hassan Abdullah here in the San Francisco Bay Area, and I'm preparing this video to discuss a very interesting and very important news topic. This is about the I-601A Provisional Waiver. It is new, and I want to provide some important facts because anytime something new comes out, there's a lot of misinformation and disinformation out there, and I'm going to prepare this video so as to educate the public any way that I can on this interesting topic. It is very useful and very valuable. It is going to be very useful and very valuable to those who came to the United States illegally or without inspection, that is, and now have a U.S. citizen, spouse, or parent who can sponsor them for a green card, and they need to leave the United States to apply for a visa. And if they do, they will trigger a 10-year bar. This waiver helps people in that situation. So I want to go over 10 important facts. So I'm going to, at the start of this video, I'm going to go over these, list these 10 facts really quickly, and then elaborate on them in more detail throughout the remainder of the video. So fact number 1, it's not available yet. It is provisional, it is not available, but it should be soon. Fact number 2, you must be the beneficiary of an immediate relative petition that is approved before you can actually qualify for the application for the waiver, the provisional waiver. It doesn't help you if you're in removal proceedings. That's fact number 3. Fact number 4. It will not work if you have an immigrant visa appointment scheduled by the Department of State. Fact number 5. It only considers hardship to United States citizen parents and spouses. Fact number 6. It only waives the unlawful presence bar, not any other inadmissibility bar. Fact number 7. You still have to leave the United States to apply for the visa once this is approved. Fact number 8, it does not provide any lawful status in the United States. Fact number 9, it does not toll unlawful presence. It does not toll the accrual of unlawful presence. And fact number 10, there are no interim benefits that accompany this application, such as work authorization. So, let's go from the top. What was fact number 1? Well, fact number 1, like I said, is it is a proposed rule. It is in the Federal Register. It is a proposed rule. It is not finalized. But when it is finalized, and it should be, and it very likely will be, then people may apply. USCIS on their website even said, look out for unauthorized practitioners, notarios, who might take people's money saying, we'll help you with this new provisional waiver. You heard about it? You know about it? Well, we got the solution for you. It's not ready yet. So when it's ready, we're going to know. But it should be ready sometime later this year anyway. Number 2, you must be the beneficiary of an immediate relative petition. It has to be approved. So what that means is that you cannot file this when this is available. You can't file it concurrently. You won't be able to apply for the waiver at the same time as the I-130 when it's filed. You have to wait for the I-130 to be approved first. And it has to be an immediate relative petition, meaning U.S. citizen parents, child sponsors you, or petition, actually no, from U.S. citizen parents or spouse. Basically an immediate relative petition. Another thing is, it's not going to help you if you're in removal proceedings, okay? So if you are in removal proceedings, you're not going to get any benefit out of this, okay? So it's not going to take you out of removal proceedings. If you do apply for it, you get it approved, I would imagine that a good strategy may be to apply for voluntary departure, trigger that bar, come back, because you have the provisional waiver approved. Next is you can't have an immigrant visa appointment scheduled by the Department of State. So if you're already going through this process, let's just say you have an appointment at you're outside the country already, and you have a visa appointment, you can't just skip the visa appointment through this process. Okay. You're going to have to go to your appointment, and you can't apply for the provisional waiver. Next, you have to show hardship to a U.S. citizen spouse or parent only. So if the hardship is upon your exit, the hardship will be experienced by children who are U.S. citizens. You could arguably still count that, but only in as much as how much it's going to impact the U.S. citizen spouse. So if your kid has some special needs and you leave the country, it is obviously going to harm the U.S. citizen parent who may have to work harder to manage that condition. But generally speaking, it only they will only look directly at the hardship of the U.S. citizen spouse or parent. And it's interestingly enough not counting permanent residents. Typically, I-601, you can include the hardships to permanent residents as well. Next, point number 6, it only waives the unlawful presence bar. So if you have other bars such as criminal activity in the past, it's not going to waive those bars. You have to qualify again through the typical I-601 when you apply for the visa. So, of course, the unlawful presence bar is the one where if you're in the United States for a year or longer and you come back, you are barred for 10 years. So this will waive that bar in advance of leaving. That's basically all it does. You must still leave the United States, that's point number 7, to apply for the immigrant visa. So when the waiver is approved, when this provisional waiver is approved, you're still going to have to actually leave, trigger the bar, and then come back. But the bar will be waived because you have this provisional waiver approved. It doesn't provide lawful status in the United States, which is important. All it does is prospectively waive that unlawful presence bar. It does not toll, point number 9, it does not toll unlawful presence. So if you've been here for less than 180 days, you better get going. You better leave before you trigger that 3-year bar. Or you might trigger a 10-year bar if you're here for more than a year. So don't rely on this waiver to think that you can toll the inadmissibility bar. Finally, point number 10, it doesn't provide any interim benefits such as an EAD, a work authorization, or ability to travel and come back, such as an advance parole. So those are the basic facts. These are some of the interesting twists that have come out with this. Some of them I didn't expect, like not being able to count hardship of U.S. citizen children. But again, you can do that indirectly. So it's a great benefit for people. It is going to be a great benefit, and we're looking forward to seeing this finalized, and it should be finalized sometime this year, 2012. So I hope you found this video to be useful and helpful, and thanks for watching, and bye for now.